Well, Times now has accessed the order copy on Manish Sisodia's bail by the Supreme Court. The court has made some serious observations, and we shall quote from some of them. One of them, of course, is an operative para that says, we can say that it appears that the trial courts and the high courts attempt to play it safe in matters of grant of bail. It is high time that the trial courts and the high court should recognize the principle that bail is rule and jail is the exception. We have Bhavtosh as well as Amita joining us. Amita will take us through the operative excerpts of the Supreme Court judgment. But before that, Bhavtosh, coming to you. Questions being raised on the part of the court in this pressing matter over the delay in investigations as well as the trial, and also a word of advice to the lower courts in this country as well as the High Court when it comes to grant of bail.
Yes, Siddharth, that's one of the major points that has been addressed by the Supreme Court, and one can expect that Supreme Court's order and observation will be followed by the trial court as well as by the Supreme Court. Remember, Section 45 of PMLA is a very contentious issue, and it has caused a lot of consternation, and it's being addressed by the larger bench. But trial court as well as High Court have refused bail to many individuals, including some high-profile politicians as well as businessmen. And the Supreme Court today had said that trial court as well as High Court should have given bail to all individuals who have in fact been incarcerated for a very long time. And because of that, Supreme Court is now clogged with thousands of cases. As far as this case is concerned, at least 69,000 pages of documents have been filed. There are 490 witnesses, and the trial has not yet started. It was way back on in 7th of August that the first FIR in this case was filed. And as far as the money laundering case is concerned, ED filed the money laundering case on 23rd of August, and the charges have not yet been framed. Now, that's the question that has been asked by the Justice Gawai, as if the charges have not been framed, then when the trial actually will start in this case. 8 supplementary prosecution complaints have been filed, 5 supplementary charge sheets have been filed by the CBI, but the trial has not yet been started, and that's the issue. This issue has been addressed by the Supreme Court. One hopes the trial court will in fact process the bond application, and Sisodia is released from Tihar jail this evening itself.
All right, we'll wait and see if that happens. Bhavtosh, let me go across to Amita as well, who has the order copy with her. Amita, take us through the operative portion.
Right, because what you were mentioning as far as the scathing observations that have been made by the court in this order copy that now we have accessed, Siddharth, that also says the court further observes that over a period of time, the trial courts and the high courts have forgotten a very well settled principle of law that bail is not to be withheld as a punishment. From our experience, we can say that it appears that the trial court and the high court attempts to play safe in matters of granting bail. The principle that bail is a rule and refusal is an exception is at times followed in breach. On account of non-grant of bail, even in straightforward open and shut cases, this court is flooded with huge number of bail petitions, thereby adding to the huge pendency as well. It is high time that the trial courts and the high courts recognize the principle that bail is the rule and jail is the exception. And of course, also talking about Article 21 liberty, as observed again, the prolonged incarceration.
Very serious observations indeed.